We now have the Professor Pablo Martín Rodríguez. He's Professor of International Law and European Law at the University of Granada in Spain. He will talk about the rule of law in Europe's regional peculiarities. So, adelante, Profesor Pablo Martín Rodríguez. Adelante, por favor.
Hola, buenos días. No sé si se me escucha bien.
Perfectamente.
Thank you very much. Good morning, everyone. Bonjour à tous. I would like, first of all, to thank the organizers of this third world meeting of International Law Societies, and in particular our host, Peruvian Society for International Law, for having invited me to take part in this major event. I also would like to tell you how sorry I am. I haven't been able to make it and to be physically present there in Lima. I would have loved it, but sadly I couldn't. So thank you also for letting me address you in this way online. As said by the chair, I am going to talk about certain regional peculiarities of the rule of law in Europe, mostly in the European Union. And the first thing I would like to say, I will try to keep my speech under 15 minutes, as I've been told, is that I'm not I don't want to talk about international rule of law, which, as Professor Salina has taught us, is quite a complex issue, but about the rule of law as a condition to be met by states. I think that in international law we can find certain rules that are connected to the rule of law as a notion, but I think that this is a sort of a fragmentary recognition. Therefore, I think that lacking this general binding definition, or this binding definition on general international law, the rule of law becomes a legitimacy condition applied in international settings, such as international organization and such. So we need this kind of legal basis, either in the treaty or in an institutional international legal act. In this sense, the European Union has a robust treaty foundation. Article 2 of the Treaty of the European Union said that it's as follows: the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. These values are common to the member state in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. So we have this robust or firm treaty foundation. But I think, and here comes probably the first peculiarity, is that I think we can find a European consensus on the rule of law, which is some sort of version in between traditional approaches to the rule of law. We know that there are so-called theme version, which are approaches mostly based on formal components, and also thick versions, which are more in focus on substantive matters such as democracy and also fundamental rights. I think that in the European Union we have some sort of a thickened version, which has formal components but understood in the light of other components. Also to the point that we have for the first time, I think, a binding legal definition in Article 2 of regulation on the general regime of financial conditionality for the protection of the EU budget. If you see, this is a good example of the thickened version, because it said that the rule of law includes the principle of legality, implying a transparent, accountable, democratic, and pluralistic lawmaking process, legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection, including access to justice by independent and impartial courts, separation of powers, and non-discrimination and equality before the law. The rule of law shall be understood having regard to the other union values and principles enshrined in Article 2, as mentioned. So we have this firm condition, but we also, I think that this legitimacy condition entails, at least in the European Union, 3 dimensions. It's a condition for legitimate membership because it's an accession requirement as provided for in Article 49 of the Treaty of the European Union. But here comes probably a second peculiarity. It's a condition for legitimate functioning of the European Union. in order to grant compatibility of the European Union legal order with the constitutional settings, the constitutional legal system of the member states, it has to be translated, this notion, to the EU itself. And in this operation, in this translation, which is a quite, in my opinion, a sophisticated legal operation, respect by the member state when applying EU law is crucial to this respect. And finally, it's also a condition for legitimate permanence. I mean, what to do, what can we do when a member state is reluctant or is violating this notion, the rule of law? Because here it emerges the dimension of expulsion or enforcement as such. And here we can say that Article 7 of the Treaty of the European Union is not, is only a political sanctioning mechanism which may end up in suspending certain member state rights, but a member state cannot be expelled from the European Union for violating the rule of law. It's different in other European institutions, as we know as the Council of Europe. So I think that what has made emerge these peculiarities is that two conventional assumptions have proved wrong later. This assumption is that once a state is part of the EU, it's going to be an increasingly better compliance with the rule, or membership would prevent involutions. Having this proved wrong, I think that we have to be aware that the third dimension, the dimension of the rule of law as a legitimate condition for permanence, i.e., the enforcement of the value, has pointed up as the main issue. And I think that here we can just admit that the political mechanism that Article 7 I mentioned before has been spectacularly failed. It has been a failure. So it has made emerge the third peculiarity, which is the judicial defense of the rule of law. And in this defense, I think that the main legal problem or legal issue, legal concern, is the competence gap. Because the EU needs to control the respect of the rule of law even beyond the scope of EU law. And this is quite a complex, I think, issue and endeavor. So, however, the Court of Justice, the Luxembourg Court, has embarked on this jurisdictional defense, and apart from some question in judicial cooperation in criminal matters, sorry? Oh, I thought you were talking to me. It has reinforced the rule of law in this three dimension I mentioned before, as an accession requirement, because the court has said that there is in EU law a principle of non-regression, which means that once the state is part of the European Union, it cannot reduce the level of protection of the value. Also, as a legitimacy condition for functioning, because the court has said that respecting the rule of law is a condition for the enjoyment of all the rights deriving from the treaties to the member states, but also as a legitimacy condition or condition for legitimate permanence, because the court has admitted that the EU has or possesses implied competence to defend the rule of law to the full extent of its power, within the limits of its power. And in this regard, the court, which has done, in my opinion, is to reinforce the binding nature of the value of the rule of law. It has done that by connecting the rule of law to other pieces of EU law, holding or saying that these rules give concrete expression to the notion of the rule of law, and so on, and so it can have binding binding nature, direct effect, etc. It has happened with general principles of EU law, also in some particular mechanism, which is the cooperation and verification mechanism regarding Romania and Bulgaria, and particularly with this Article 19 of the Treaty of the European Union, in which the court has stated that this is a rule regarding effective judicial protection, which gives concrete expression to the rule of law and has not only direct effect and a binding nature, but it has a larger scope, not requiring an actual application of EU law. It has also done that with admitting or assuming the validity of this financial conditionality regulation, and it's still pending. This case I mentioned here, Commission v. Hungary, it's still pending, but in this case, the court is being asked to rule on whether Article 2 may be autonomously applied. That is, if Article 2 is binding by itself. We will see what the court will say. Sorry. Of course, this judicial defense hasn't come without a price, I think. I just mentioned here three of the risks I think that it implies, this answer, this response, judicial defense implies, which are probably the first one is more of a technical nature, because this case law is quite problematic, and we can even say that it's not fully consistent with other parts of the EU court case law. The second one is more of a legal policy nature, because this case law has provoked clear constitutional resistances, especially by certain constitutional courts, like in Poland, Hungary, and Romania. And the third one is more of an institutional problem, in my opinion, or a risk, because even if we are talking about the rule of law, and this means a lot about judges and courts and tribunals, I think, in my opinion, there has to be a defense of the rule of law beyond the jurisdictional realm. So, summing this up, which are these specific European features regarding the rule of law? In my opinion, they are these four. The first one is this European consensus on the rule of law, to the point of having a binding, legally binding definition on a thickened version, which is formal components understood in a substantive manner. The second one is the application of this notion to the European Union itself, and not only to the member state, which is a quite complex and interesting thing. And I would recall that the intervention or the presentation of Professor Salinas before, how difficult it is to apply this notion to the international legal setting, to an international legal setting. The third one is the reinforcement of this notion by making it to encompass several legal obligations. We are not dependent on an actual application of EU law, which is quite interesting. We can see that in this non-regression principle in Article 19 and another. But finally, I think that this jurisdictional defense may point to a fourth specific European feature, which is that this jurisdictional protection is on the value itself. And I think in different international, in other international settings, we can find some sort of protection of the rule of law, but it's, in my opinion, mostly individual rights connecting with the rule of law, but not the rule of law itself. So I think these four may imply or may point to these specific European peculiarities. And I just thank you for your attention, and I give the floor to the chair. Thank you very much.
Thank you so much, Professor Pablo Martín Rodríguez, for this very substantive reflection on the contribution of European law to the notion and the ideals of the global rule of law amid the peculiarities and complexities of the European legal systems.